Good afternoon, ladies and gentlemen, and thank you for the opportunity to join you. I am Chief Alaric Fox of the Enfield Police Department. I have had the opportunity to serve the town of Enfield as police chief for the past 3 years. This is my 38th year in the law enforcement field. I have had previous career stops as a Willimantic police officer, an FBI agent, an attorney, and with the Connecticut State Police, from which I retired in 2018 as the State Police Colonel and Deputy Commissioner of the Department of Emergency Services and Public Protection. I join you this morning to offer my support for Sections 6 and 7 of Raised Bill 1093, an act concerning civilian police review boards, security guards, body-worn recording equipment, and searches by police. I have submitted written testimony in this regard, and I would invite you to review this material at your leisure. I would take the liberty, however, of drawing your attention to the high points of my submission. During the last legislative term, Connecticut General Statutes 5433B and 5433O were modified to effectively eliminate the vast majority of what we traditionally refer to as police consent searches. Please know at the outset that I and the substantial number of police chiefs that I have spoken to share the discomfort that some have expressed that the mere asking for consent to search has been exercised in a haphazard or inappropriate manner. What is before you is a fair resolution of the competing interests in this area. The search warrant exception represents a valuable tool in our ability to ferret out criminal offenses that harm your residents, that denigrate your community, and that challenge my coworkers. To this end, Sections 6 and 7 of Raised Bill 1093 seek to modify the consent to search exception, but with significant safeguards in place, namely the satisfaction of a reasonable suspicion threshold before consent to search can even be asked for, a written reporting requirement on any such encounter, and of course, any such interaction will now be recorded on a body-worn camera. All of this even preceding the subsequent judicial motion to suppress, which allows a degree of certainty that any consent to search that was obtained in a legally sound manner. It's my hope and belief that these sections represent an appropriate compromise that balances out the sometimes competing interests of individual liberty with the obligation to ensure the public safety, and that as such you consider these aspects of this legislation favorably. Thank you.
Thank you, Chief. Questions or comments from the committee? Are there questions or comments from the committee? If Representative Doucette.
Thank you, Mr. Chair. I was slow to get my hand up there. Hi, Chief Fox. Thank you for your testimony today.
Thank you, sir.
Quick question. Do you have data either from your own department or from your experience, or is it elsewhere, about how often or how many consent searches were conducted over any period of time in the state of Connecticut? My conversations over the last year, especially with chiefs and officers, is that it's not frequently used, and I suppose it can vary from department to department. But do we have good data on how often or how many consent searches are conducted in any given year?
I could certainly compile it, as I suspect other chiefs could compile it for their individual departments. I think that the data in total is contained within the CCSU work if the consent search request flows from a motor vehicle stop. A consent search request for an individual on the street would not be realized in that reporting mechanism. It would require a hand count or at least a computer analysis to generate that portion of the data.
Okay, that makes sense. Okay, so I'll look for that. Be interesting to see. And can you explain as well, you touched on the search warrant exceptions, how those come into play under current law, and what your proposal would be to amend this legislation on that?
Yes, sir. So in training of police officers and in constitutional practice, the threshold position and sort of the default rule, if you will, is that any searching or seizing requires a search warrant. This is Constitutional Law 101, Fourth, Fifth, and Sixth Amendment type material. Having said that, there are a number of recognized search warrant exceptions that have been developed judicially that have existed for decades, for centuries, that predate the formation of this country as a country in terms of our broader system of jurisprudence. And at the risk of it getting overly wonky, we refer to these as Carroll car searches. There are Terry pat-down searches. There are exigent circumstances searches. There are probably, depending on who's writing the list, 10, 11, 12 search warrant exceptions. One of those exceptions, and a rather robust one, is the consent to search exception, which recognizes the ability of an individual to say, I agree that a government agent can pat me down, can search me, can check my car, can check my pockets, subject to the government satisfying that search was obtained in a knowing, intelligent, and voluntary fashion, and a pretrial motion to suppress held by a judge in any subsequent criminal case. We went from the robust consent to search exception prior to last year to a rather limited consent to search, a highly limited consent to search exception as a result of the Police Accountability Bill. And please know, as I referenced, we understand the concerns and the consternation that was driving that. Having said that, what you have before you now is the consent search in a modified form. It would allow for law enforcement to ask an individual for consent to search, but it couldn't be done, and it wouldn't be done in any sort of a haphazard fashion. It could only even be asked for upon the satisfaction of what we refer to legally as a reasonable and articulable suspicion standard. That is what is contained and built into Section 6 and 7.
That's helpful. I appreciate it. So I guess the last question would be, is it your contention, and again, maybe this is delving too deep into and getting wonky, as you say, but is it your contention that either current law is not in keeping with Fourth Amendment jurisprudence across the country or Supreme Court or what have you, and or that this bill would be more consistent with other states and with the Fourth Amendment?
Frankly, I believe that the majority rule, if we were to canvass the nation at large, is rather the unfettered consent to search, with an understanding that at this point that is not where the state wants to go. You would be adopting a rather hybrid rule that's somewhere between a minority, a handful of states that prohibit consent searches in total, and the majority of states that allow the police to ask for consent. So you would strike a stance that is this hybrid. It would still be on the very restrictive side in terms of the ability of law enforcement to engage in this behavior when compared to our brother and sister states.
Okay, but that's sort of where we are now, though. In other words, as you would say, more restrictive, but it's not as if we completely eliminated or out of line with the Fourth Amendment by under current law, right?
Sure. The Fourth Amendment would set a minimum of rights. The way that I describe it to both police officers and to college students that I instruct is the Fourth Amendment sets a floor, it doesn't set a ceiling. So states, of course, are free to come along, as I'm sure all of you know, or many of you know, at least in terms of Fourth Amendment law. States are free to come along and set the threshold, as Connecticut has done in many areas, at a level that's different than the federal minimal level of constitutional protections. So I wouldn't say that we're not inconsistent with the federal law, but we are more restrictive in terms of what we currently have. And you'd still be more restrictive in terms of the language. You'd just be less restrictive than what we currently are, if that's not spinning it too many times on you.
No, that makes sense, and that's helpful. I appreciate your testimony and your answers. Thank you, Mr. Chair.
Chief, just before I turn to my other colleagues, just on that point, by way of follow-up, what is currently on the books in Connecticut after last summer's police accountability bill, the the consent search provision from last year's accountability bill. Is it your understanding that that language as is still more permissive for police officers than some of our surrounding states, and most particularly Rhode Island? Do you have knowledge on that?
I don't. The only state that I know of with certainty that is at where we are at right now, I believe Washington State is consistent with the position that we have here. I'm not in a position, unfortunately, and I apologize, but I'm not in a position to do a state by state. If the implication is that this is where Rhode Island is, I wouldn't be in a position to dispute that, sir. No.
Okay, understood. Thank you. Representative Fishbein.
Thank you, Mr. Chairman. Good afternoon, Chief. Long time. Haven't seen you in a while. But
good afternoon, sir.
How you doing? Just centering on this discussion, when you reference haphazard, do you mean what you mean by that? And I don't want to put words in your mouth, so to speak, is disparate or subjective on the officer as to whether or not they're going to ask for a consent search? Was the process prior to the current law?
That has certainly been the concern that's been expressed, and there is some data to support that. It's not every year. It's not an amalgam of data, but certainly there has been some data that expresses that concern. I can tell you that haphazard or disparate or discriminatory is not behavior that I have ever engaged in, and not behavior. And I say this, forgive my passion. But that's not behavior that I've ever engaged in, nor behavior that I have ever seen engaged in my state police career, and certainly would never be tolerated. And I haven't seen it in my Enfield career. But it's difficult to argue with the data, some of the more recent data that we're all familiar with. And that's why I think what is before you is an effort to reconcile these two interests that I'm referring to. Yes, sir.
Yeah, and the disparate application opens that up to possible discriminatory practice.
That is the concern that has been expressed. Again, I am very pleased that I can look at this with rose-colored glasses and tell you that I haven't seen that. But certainly the data that's been generated out of the CCSU work is a cause for very significant concern. And I think that's what brings us. I appreciate that question, because I think that's what brings us to this discussion right here. God bless you folks, because you've got these competing interests that you have to satisfy. How do you take action that assists the public in having the safety and security that we know they want in every community, at the same time ensuring that law enforcement procedures are consistent legally and morally with what we very appropriately demand of public servants? How do we get there? What is before you is a way to get there. Much more restrictive than the majority of our states, but it would restrict consent searches to that reasonable suspicion standard.
I appreciate that, and I'm just trying to clarify your representation to us. The current law is, through your investigation, experience, review, the minority law across the country. Is that what you're telling us?
Yes, sir, it is. I have the great pleasure of teaching nationally, training police officers on a national level. And in speaking to officers, the default position, again, I can't give you hard data. I haven't surveyed the states. But the default position, anecdotally, in my interaction with police officers, is the unbridled consent to search, where Connecticut previously was, where we're not trying to go with this legislation, is clearly the default rule within our nation.
Yeah, if we were to create two bookends, that's one bookend is the current law. And then we have this unfettered right to ask for a consent search, which is the other bookend, which is where we were. Is that fair to say?
It is, sir, yes.
And this legislation brings us somewhere in the middle area. Is that fair to say?
I think it's fair to say the middle, perhaps leaning a little bit more toward the restrictive side in terms of the number of states. I think you're still comfortably, presuming that's where you want to be. I think you're still comfortably with that group of states on the far bookend.
And
bookend closest to the, I'm sorry, the bookend closest to the camera, if that's helpful in terms of how you used your hands.
Sure. And, under the under the present standard, probable cause, would there be required that a report be done if the officer says I had probable cause and therefore asked for a consent search?
I can envision no situation where a car is getting searched and a report is not being done. So I'm very comfortable responding to that question in the affirmative, both under the practice of any department that I'm familiar with. Additionally, because the officer is going to need to document what their probable cause is to justify their behavior. So I'm very comfortable answering that in the affirmative.
Okay, although it isn't required in the language.
Correct. And actually, to that degree, you could look at the proposal that's before you as actually formally instituting another step to ensure the propriety through the documentation on the part of the officer.
But if you could explain what you mean, I mean, for the purpose of the public hearing, what that means, what portion of this language gives that additional assurances when a consent search happens under this new language, should it become law?
Sure, I'd be happy to. So the current language requires that the consent to search be that a consent search only be executed, or it describes it in the negative, that a consent search will not be executed absent probable cause. So it sets a legal threshold, but it does not go on to include the reporting mandate, even if I think it fair to say that a report would be generated as a matter of course in any such situation. That mandate is not contained within the current law. So in the proposal, what you're effectively doing is you're altering the standard from probable cause to reasonable suspicion. And that's what I urge you, I ask you to consider. But the proposed language formally includes the reporting requirement. So it's almost as if you're altering in one direction on one issue, the legal standard, but you're altering in the other direction, the reporting mandate within the new language.
Well, I thank you for that. And I, the concern, whether a report gets done or not under the current language, you do have the opportunity, I guess, for discriminatory practice under the current language. If you're not being required to articulate that probable cause, therefore initiating the consent search under the current language. So yeah, I agree. This is an additional protection for civil rights of our people. And I thank you for coming here to testify. Thank you, Mr. Chairman.
Thank you, sir.
Thank you. Representative O'Day.
Thank you very much, Mr. Chair and Chief. Good to see you. It's been a number of years. I think the last time was we saw each other was when I was at Post, or it used to be the MPTC. But I just pulled over. I'm on the side of the road because I wanted to thank you for your years of service with not only the state police, but also to the good citizens of Enfield. And I want to thank you for your testimony. I'm looking forward to working with you to try and get this legislation through. So thank you very much. Thank you, Mr. Chair, and appreciate the time.
It's my honor to do so. I appreciate your kind words.
Go ahead, Representative Howard.
Thank you, sir. So, Chief, I certainly agree with you that oftentimes, good police officers doing a good job doing a search, whether or not it yields any evidence or contraband, should be doing reports. But would it be fair to say, Chief, that previously, before 20-1, if an officer asked for consent and the person told them no, that the officer probably wouldn't do a report on that? Is that a fair statement?
I would agree with that. I mean, absent the underlying event, of course, being something that prompted a report. Agreed.
So under this new legislation, we can really, truly capture, correct me if I'm wrong, but as you read it, we can truly capture who's asking for consent when, whether or not it's granted or not.
That's a fair point, because that's a fair point. Thank you. To the extent that the consent is given, my stance was and is that the report would likely have been written before. Now it's going to be mandated. To the extent that consent is asked for, the officer believes they're at reasonable suspicion, but it isn't given, the new reporting mandate would kick in. That's an interesting assessment, and yes, it appears to be correct.
Thank you for that, Chief. So I think that's an important thing that we're recognizing here is what we're doing is we're telling officers in this new legislation, if you're going to ask for consent in the interest of doing your job to protect the public, you need to tell us why you did that, and it better be a good reason. Is that a fair statement?
Yeah, now that we're and I appreciate the opportunity to parse it out because yes, whether or not the consent is granted, complete the police report.
So I think,
yes.
Thank you, Chief. Sorry. So I think that's an important thing. And one other point that I want to make out because and I agree with you, and I certainly agree with my friend Senator Winfield in that we have to strike a balance, right? And that's a line that police officers walk every day to try to protect people's rights, but protect the public at the same time from those who do them harm. And there's a very thin line, as you well know. But would you agree? You had an impressive career, certainly. Did you ever work in narcotics, Chief?
I have, yes, sir.
So, just when you worked in narcotics, did you did you work confidential informants and do controlled buys?
Yes, this was at one point during my FBI experience, my FBI agent time. Yes. So, for my colleagues, when tell me if this is accurate. When you can conduct a controlled buy of a narcotics dealer, you have a confidential informant who meets up with you. That confidential informant is knowingly meeting up with you to do a controlled buy. You search them and their person with consent from that person on their car and then they get kept under surveillance to the target, through the target, and back to a prearranged meeting spot. Therefore, you can then testify in court, if necessary, that your confidential informant didn't have any narcotics on them prior to going to the target, and therefore you know the narcotics came from the target, and that consent search of that CI is necessary in the investigation. Is that true? It would be indispensable to making such a case. Okay,
thank you. So, and then also in the course of your career, we use DNA in police work often now, and oftentimes at burglaries and things of that nature, we need to get consent from victims and sometimes witnesses for swabs of their own buccal swabs or DNA, their inner cheeks, which is in effect a search based on their consent for exemplary purposes. Is that correct?
It is correct.
And would you agree with me that the language as it sits, not the proposed language, but the language as it sits in 20-1 is makes those searches in effect illegal?
I believe that it does. We have that was one of the areas of discussion very early on, the elimination of individuals as a potential party to a crime. Under the current language, unless we're at the probable cause standard, we're not even asking.
Well, let me say this to you, Chief. I am grateful that someone with your law enforcement background, your position, your education is able to stand publicly and say, hey, I hear the concerns, I understand the concerns, and I share the concerns. We can achieve the goal to abolish those concerns and make sure we have all the safeguards necessary to stop the activity that those who are concerned about, but at the same time, enable our police officers to do the good and noble work that they've been doing. So, Chief, I thank you so much for coming here and articulating that so well. Thank you, Mr. Chairman.
Thank you, sir.